my pleasure. Welcome everybody to our first keynote speech. I introduce Niamh Dunne. Niamh is a professor at the London School of Economics and Political Science, and in law, I should add, and before she held positions at King's College and at the University of Cambridge. Niamh, for a long time, had a focus on the interrelation between competition law enforcement and, well, other branches of market regulatory law. Today, she's going to speak about regulatory gaming strategies in EU law. And we are very happy to have you today. The floor is yours.
Good evening, everyone. Thank you. It's a real privilege and pleasure to be here. I am going to break one of the unwritten rules of, I think, contemporary competition law conferencing, and I'm not going to give you a shiny, techie digital markets topic. Regulatory gaming is something which has arisen perhaps less in digital markets, not least because one of, I suppose, the defining features of digital markets for the last couple of decades has been an absence of regulation, so an absence of opportunities to game, although there is one tech case in the bundle I'm going to talk about today. Instead, I'm going to give you some more analog markets. We're going to have cars and trains and beer and retail banking. And I'm going to try and make the case that regulatory gaming is a phenomenon that merits, I suppose, consideration from a competition law perspective. There are benefits to looking at these cases in total, not least because they raise some, I think, important enforcement challenges. They raise some important competition policy questions. And even if I don't succeed in persuading you of the merit of the topic as such, at the very least, hopefully I will persuade you of the ingenuity of firms when it comes to finding ways to evade regulatory constraints to their own advantage. Very briefly, I'm going to talk about regulatory gaming and what I mean by this concept in some perhaps exhaustive detail later in the presentation, but to give you an introduction to what I mean generally, I'm talking about behavior by firms, regulated entities that involves manipulating or even subverting the regulatory framework in order to achieve anti-competitive outcomes. So as a theory of competition law harm, what is distinctive about regulatory gaming is that it makes compliance with one set of legal rules, i.e. competition law, contingent upon compliance, or at least the manner of compliance, with an entirely different set of regulatory rules, whether they are sector-specific regulation in utilities or financial services, IP law, data protection rules, environmental protection rules. There's going to be lots of different regulatory regimes in the bundle of cases I'm discussing today. And so these cases raise, as I'm going to try and argue, they raise substantive questions about legal standards for intervention. They raise institutional questions about who should be pursuing these cases. Is it legitimate for competition authorities to take on these cases? And I'm going to hint at the end at some of the compliance concerns these cases might raise. Before I do so, I'm going to very briefly introduce the general landscape in terms of the relationship between competition law and regulation in the EU. So any of the competition lawyers in the room, this material is going to be very familiar, but it's really just sort of setting the scene for the more general discussion to follow. It is, of course, a cliche that markets in Europe are pretty heavily regulated, both at a national level and the red tape that comes from Brussels. These regulations touch on essentially every area of business activity potentially. Very often the regulation is very far from the substance of any antitrust theory of harm, but it can impact on competition in the market and how a firm can compete in the market in significant ways, raising barriers to entry, generating market power, generating scope for countervailing efficiencies, or preventing countervailing efficiencies from arising. And EU competition assessment is alive to this fact. In principle, you take into account the entire regulatory framework alongside the legal and economic context when you're assessing whether there's a violation of Article 101, the rule against cartels, or Article 102, the rule against abusive dominance. I think the orthodoxy is well sort of put in the Budapest Bank case from a few years ago, where the court said when determining whether a restraint amounts to a violation of the competition rules. Regard has to be had to the legal and economic context of that practice. When determining that context, it's also necessary to take into consideration the real conditions of the functioning and the structure of the market in question. This, of course, is necessarily going to include the existence of regulation, which might be influencing or distorting competition in the market. So that's the orthodox position. That might be easier said than done, but certainly EU competition law accounts for the existence of regulation in the very substance of the prohibitions. That being said, EU law conceptualizes competition law and regulation as two distinct barriers to lawful market participation. So in principle, economic operators, if they're subject to regulatory obligations, they're supposed to comply with those regulatory obligations alongside and in parallel to their competition law obligations. So each imposes distinct requirements, each is enforced by different regulators, and it's up to the economic operator to make sure that its behavior is in compliance with both regimes. This means, firstly, that the pre-existence of regulation does not oust the jurisdiction of the antitrust rules 101 and 102. Undertakings have to comply with both sets in tandem, and this is quite different to the approach in the US, where there's a pretty broad doctrine of implied immunity, where the existence of a regulatory regime that is somehow said to perform the antitrust function essentially ousts the jurisdiction of the Sherman Act of the competition rules over the same behavior. So a much more generous application of competition law in regulated markets in Europe. This means this two barriers idea means that there's no necessary relationship between these two ideas, however. So conduct that is compliant with sector-specific regulation may nonetheless breach competition law. So the fact that you comply with intellectual property rules with respect to your patents, or that you are complying with, say, data protection law or other sector-specific regulation, does not mean that the same behavior, the regulated behavior, is also going to be okay under the competition rules. Vice versa, non-compliance with sector-specific regulation doesn't necessarily indicate a breach of the competition rules. The ASNEF Equifax case is a good example of this, where the court very clearly says the fact that an agreement might be in violation of data protection rules is not, for that reason alone, also a violation of Article 101. It could be a violation of Article 101 if it generates significant market power, which distorts competition in some sense, but the mere fact of a violation in one area doesn't always translate into an antitrust violation. There is a little bit of a gloss on this where the regulatory regime seeks to apply or to operationalize competition law principles. There are some recent cases which suggest that breach of that regulatory regime is particularly relevant in informing a potential breach of Article 102 in those cases, but it's not an automatic transferal. There is a narrow exception in the case law for state action. So this is where either EU level or domestic regulation compels a defendant to breach competition law, or where the regulatory regime removes any possibility for lawful competition. So an example of the first might be where the regulation requires, for instance, undertakings economic operators like architects or lawyers to enter into a price fixing agreement by setting minimum fee scales. That looks like an anti-competitive cartel, but if they've been required to do this by law, they benefit from the state action defense. An example of the second would be, I think there's a great example in the gas pipeline market sharing cartel between the German and the French natural gas incumbents. They collaborated building a pipeline, bringing natural gas to Western Europe. They agreed in doing so not to enter each other's home territories. The French operator would stay in France, the German operator would stay in Germany. They adhere to this for several decades. It's ultimately held to be a market sharing cartel. And the Court of Justice says later on, yes, it is a market sharing cartel, but in the initial stages, actually both of the home territories were protected by legal monopolies. And so there was no possibility for lawful competition in those markets, and so no possibility of unlawfully restricting competition as a result. But this is a really narrow defense. So to the extent that there's any scope for what's called autonomous conduct on the part of our defendants, it can be scrutinized under the competition rules, regardless of how closely they are regulated, regardless of the fact that the regulation may have a very significant impact on levels of competition in the market, may also have quite a significant impact on the behavior facilitating, encouraging anti-competitive conduct. The only way in which we can reflect this, I suppose, contribution that might be made to anti-competitive outcomes by a regulatory structure if the state action defence does not apply, and it almost never applies, would be if you have a reduction in fine. So the Commission has a discretionary power to grant a reduction in fine to reflect lower levels of culpability because the regulation somehow encouraged or facilitated the breach. But otherwise, a very broad rule that competition law remains fully applicable to regulated behaviour in regulated markets. Which brings us back to regulatory gaming. So regulatory gaming is a phenomenon which I think is more well recognized and theorized in the economics literature, the kind of the regulatory economics literature, than in the legal literature as such. In competition law terms, I think the leading piece on this concept is an article published in the Texas Law Review in 2009 by Stacey Dogan and Mark Lemley. And they were actually writing in response to a number of cases I mentioned on a previous slide, Trinco, Credit Suisse, where the Supreme Court adopted this very restrictive approach to the application of competition law in regulated markets, this very broad understanding of the implied immunity doctrine. And in this piece, they're really arguing for the application of competition law in regulated markets or to regulated problems, at least in certain circumstances. And they say, look, regulatory gaming in particular is an issue that we need antitrust intervention to deal with. They define it as behavior that abuses a neutral or pro-competitive regulatory structure and wields it as a tool to accomplish exclusionary results. I think in the European context, you could also add exploitative results because, of course, exploitative abuses are also caught under the EU competition rules. And they clarify that abuse involves private conduct that distorts the regulatory process, as opposed to, for instance, a firm petitioning to try and have the regulation changed, the regulation removed in some way. So it's not about firms trying to get lawmakers to change the regulation. It's about actual interactions with the regulatory process, essentially kind of corrupting the regulatory process. And they really point to a dilemma at the heart of regulatory gaming strategies from an enforcement, from a regulator perspective. Here, regulation creates the opportunity for abuse, but almost by definition in these cases, it's unable to deal with it. The regulatory structure cannot address the problem adequately, and that's the case for competition law intervention. You need competition law because there's a problem created by regulation, which can't be fixed by regulation, and so antitrust law has to kind of ride in on its white horse and save the day. Regulatory gaming, I think I mentioned at the outset, what makes these cases interesting, what makes them distinctive, is this relationship of contingency. So where we're talking about cases where the competition law violation exists, we have a problem with, we object to our defendant's behavior precisely because of the existence of the regulatory regime and how the defendant is interacting with the regulatory regime, how they are complying or not complying with these regulatory obligations. So it's kind of antitrust law is being used to police, to supervise what's going on in essentially another adjacent regulatory field. And so really it's the defendant's deliberate or bad faith interactions with this sort of alternative regulatory regime, which provides the rationale for the competition law theory of harm. As such, these cases, I think, have to be distinguished from anti-competitive behavior that arises in regulated markets, even highly regulated markets, where the existence of the regulation may have a very significant impact on the anti-competitive outcome in the market, but it's not integral to the theory of harm. So probably counterintuitively, I'm going to start with some examples of what regulatory gaming is not before I give you multiple examples of what it actually is. So I'm not talking about situations like the bananas cartel, which is where 3 of the major bananas importers in Europe had bilateral weekly meetings to discuss banana prices and what they thought the banana reference price would be for banana markets, essentially attempting to put in place a price fixing cartel. The problem in this market was that it was essentially impossible to fix prices because so much of the market was dictated by tariffs and quotas coming from the Common Agricultural Policy. And ultimately, even though this is held to be a hardcore price fixing cartel, our cartelists get a 60% discount on their fines to account for the fact that so much of the, I suppose, lack of competition in the market was due to the regulatory structure. But this is not something that the harm here, the bad behavior is not contingent on the regulation. If you take the regulation out of the picture, this is still a plain vanilla price fixing cartel. Actually, it's a more effective price fixing cartel because you can fix prices directly. And so there's no necessary relationship between the regulation and the harmful outcomes we see, the problematic behavior. Similarly, I'm not talking about situations like the consumer detergents cartel, where 3 of the major washing powder producers in Europe collaborate in an environmental initiative, removing some of the waste from the manufacturing process. There's lots of cost savings as a result. And on the kind of in the shadows of this environmental initiative, on the side, having met and collaborated in this perfectly legitimate welfare enhancing coordination, they decide to collude in order to basically pocket the difference. They freeze prices, they don't reflect the cost savings in lower prices, they don't pass them on to consumers. Again, I don't think that's regulatory gaming. The regulatory context provides the opportunity for anti-competitive behavior, but if you remove the regulation from the picture, price freeze is still a price freeze. Let me give you some examples of what I think regulatory gaming is. So I'm going to categorize the cases in 3 broad categories, most of which the examples I'm going to give you are actually relatively recent enforcement cases of the European Commission or preliminary references from the European courts, European Court of Justice. So the first category is bad faith compliance. So this is where our defendant is subject to regulatory obligations. It complies with the letter of these regulatory obligations, but it seeks outcomes that very clearly go against the spirit of the regulation, or certainly are not intended by the regulatory regime, and would not, if you were to ask the policymaker at the time they were drafting the regulation, they would say that's not an outcome that I want. So really, what's the issue here from a kind of a competition perspective? We've got a defendant who's taking advantage of inadvertent opportunities provided by the regulatory framework to exclude or to exploit. The classic example in EU competition law, I think, would be one of the 2 practices in the AstraZeneca case. This is the kind of elder statesman of regulatory gaming case law in Europe. This involved AstraZeneca pharma companies' strategic withdrawal of marketing authorization licenses in order to stifle generic competition. So these licenses they're necessary for any manufacturer of medicinal products to put them on the market in Europe. You get them from national regulators. There's a very complicated regulatory regime at a European level for this. AstraZeneca had acquired its own MA through quite a lengthy process because it was the originator producer of the drug, but there's a much quicker, more abridged procedure for generic entrants who essentially piggyback on existing marketing authorizations, such as the one held by Astra. In this instance, knowing that its blockbuster drug, Losec, was coming to the end of patent protection, Astra adopted a strategy where they tried to migrate all their patients to a different formulation of the particular drug, which still had some patent protection, and then they just strategically withdrew the marketing authorizations. And in doing so, in a number of member states, it made it essentially impossible for generic entrants to use this abridged procedure, and it really slowed down entry into the generic market. This is something that was at the time completely compatible in accordance with the existing regulatory regime. The holder of an MA can decide whether they want to keep it in force or not, but it clearly goes against the spirit of the legislation, which is there to encourage, facilitate generic entry. I'll give you a second example, a much more recent one, AB InBev, an infringement decision. Again, Astra and AB InBev, both Article 102 abuse of dominance cases. AB InBev, the world's largest brewing company, also the dominant brewer in Belgium. And in Belgium, AB InBev has traditionally maintained much higher prices for off-trade sales of beer products, so sales through supermarkets, for instance, than in neighboring countries. So higher wholesale prices for its leading brands like Jupiler and Leffe in Belgium than in France and in the Netherlands in particular. This, of course, made AB InBev somewhat vulnerable to parallel imports from those neighboring countries. Not difficult to put cans of beer on a truck and drive them over the border. AB InBev is aware of this and really wants to protect those higher profits being earned in Belgium, engages in a number of commercial strategies which are intended to basically make it much more difficult to have those parallel imports, one of which is pure regulatory gaming. So conventionally, AB InBev had used the same packaging for each of these 3 member states. Nutritional information, contact information was on the side of the can in both Dutch and in French. And this is particularly useful in Belgium because in large parts of Belgium, to legally be able to sell a product, it has to have labeling in both languages. It's a linguistic plurality law that has specific labeling requirements. AB InBev wants to prevent imports coming from the Netherlands, where you've got these cheaper beer prices, and all it does is it stops selling the dual language cans in the Netherlands, but it only sells the cans with the Dutch language. And almost overnight, it knocks out the possibility of the parallel import trade, because you can bring the product into Belgium, but to be able to legally sell it, you're going to have to relabel it. That involves expense. It stops being worth the hassle of actually doing this. And so you really sort of neatly take advantage of a regulatory scheme that is very, very far from the kind of the cold face of economic activity, I guess. But that you're able to use it for an exclusionary purpose, completely in compliance with the domestic regulatory regime, but very effectively enhancing AB InBev's own market power. And a third example, which I think is a particularly egregious one. Often when you read antitrust cases, particularly 102 cases, you think, oh, there's arguments on both sides. This is one of those few examples where there were no arguments on both sides, or on one side at least. Aspen Pharma, another pharmaceutical company. It's essentially an excessive pricing case. They were held, it's a commitment decision a couple of years ago, but they're held to have engaged in excessive pricing for 6 cancer medications, which have been off patent for 50 years, but because of they're quite niche drugs, there's no other suppliers in Europe. The difficulty with excessive pricing in this instance is that in every member state, there's essentially a price regulation system. So how do you engage in price regulation, in excessive pricing, where there's price regulation in place because of the nature of reimbursement in the public health systems? Well, you're going to have to game those price regulation systems. Most member states in Europe use a price reference system where they set the reimbursable price at some factor of prices charged in other member states. So some member states allow a relatively high rate of reimbursement compared to other member states. Other member states pay a very low fee compared to what you can get in other member states. So Aspen's going to need to somehow find a way to get that very high price into the price reference system. So ping, 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 it will raise the prices in all the other jurisdictions. They figure out that the German regulator is particularly price unsensitive when it comes at least to the list price that's within the price reference system. And this is because German law has a clawback mechanism, a kind of tax or discount mechanism, whereby if the regulator thinks the price is too high compared to the economic value, they essentially just take back the excess money. So they don't pay the list price. But the other price reference systems, of course, don't know this. So Aspen starts with the German system, gets a very high price in. German regulator doesn't care, they're not going to pay that price anyway, but ping, 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 all the other price reference systems spit out a really, really high price. And this is, of course, they're playing with the legislation, but they're not doing anything that's illegal in any sense. Of course, the other price regulators see this incredibly high price increase. It's 200, 300% price increase compared to what had been previously being paid for a drug that's been off patent for 50 years. And so the other regulators say, we're not going to pay this. And Aspen has step 2 of its nefarious strategy. It says, fine, we will step outside the price reimbursement systems entirely. If you don't want to pay us the price that we think we are owed, we will no longer be within this regulatory framework. Of course, we're likely to make fewer sales if we're not within the scope of domestic reimbursement systems. And that's a loss for us. But it also means, to the extent that you want to source these drugs, you're going to have to go in the open market, and you're going to have to pay whatever the open market is going to charge for them. And bearing in mind that these are cancer drugs for the most vulnerable patients, so the very old and the very young, of course, it's a game of chicken with the national regulators, and the national regulators all blink first, and Aspen succeeds in getting its price increase in. So, and all of this is not incompatible with the regulation. It's certainly not what's intended by the regulation, but they're not breaking the law in any obvious sense. So this is, I think, bad faith compliance. These cases all taken as Article 102 cases. The second category of gaming cases that I think you see emerging are cases that couldn't, I think, be taken in the US. I think that the Trinco Credit Suisse line of cases would eliminate the possibility of using antitrust law in most instances. This is where you've got opportunistic non-compliance. So our defendant is subject to regulatory obligations. They deliberately choose not to comply because they make a cost-benefit analysis of what compliance is going to cost them and what would be the benefits of non-compliance. And they also factor in the likelihood of effective sanctions of the regulatory rules being effectively enforced against them, having to comply for some reason. And they know in these situations that the regulatory framework itself is simply inadequate to enforce those obligations. And they just make an opportunistic choice not to comply. They're going to take their chances. So here we clearly have regulatory failures. The defendant is taking advantage of the regulatory failures, and these regulatory failures subsequently are reconceived as antitrust abuses. You get, again, AstraZeneca is a good example of this. The case involved, the second strand of the case involved applications for supplementary patent protection, so extended patent protection. The judgment uses the term misleading applications. You actually read the facts, they're not misleading, they are fully fraudulent, fully deceptive. If we were talking to small children, we would call them lies. So they just lie to the patent authorities, and they do so because they know that there is no obligation under the regulation for the patent authorities to actually verify the information. So there's this strange regulatory compromise that patent authorities are entitled to take at face value exactly what the applicants tell them, and many of the authorities do. And as a result, Astra is able to get patent protection that it wouldn't be entitled to in some member states, and much longer patent protection that it would be entitled to in other member states. The Telekom Polska, Slovak Telecom and Baltic Rail cases are a strand of case law coming out of the liberalization regimes. Two involve telecoms, one involves rail liberalization. Under these directives, these EU-level regulatory frameworks, there are mandatory access requirements imposed on what are usually the former state-owned monopolist. The incumbent former state-owned monopolists don't always like sharing their toys with new entrants in the market. Many resist in various forms, and these cases all involve examples of resisting behavior, non-compliance with access requirements, whether it is unreasonable delays, whether it is wholly unrealistic, sort of over-the-top requirements for the potential new entrant to join the network. Baltic Rail is a particularly fantastic example where, anticipating that it was going to be asked to share access with its network with a freight rail competitor, the operator of the railway in, I think it's Lithuania, decides to physically destroy and remove 19 kilometers of track. It just says, I don't want to have to share this. This track no longer exists. You can't make me share something that no longer exists. And the regulatory framework can't deal with that. Perhaps unsurprisingly hadn't anticipated that might happen. But there are other reasons why the regulatory framework might fail. So in Telekom Polska, the regulator had in fact taken multiple enforcement actions against Telekom Polska, but the fines that they can impose run to tens of thousands of euro. And this is a company that makes 4 billion euro in revenues annually. So the fines have no bite whatsoever. Slovak Telecom, you've got a regulator who very clearly seems to be captured. There's 5 years. The market is open to new access entrants for 5 years, and not a single access request is granted over that period, and the regulator does nothing. There's no interventions, there's no investigations at all. There's just kind of, crickets, radio silence. And Facebook Germany, I think this case is probably people in the room who know a lot more about this case than I do, but I do think it's an example of opportunistic non-compliance. You've got Facebook, who's essentially the problem is its business model is fundamentally incompatible with data protection rules. They make an opportunistic choice not to comply with those particular rules. And they do so because they are aware that the enforcement framework is particularly lax, not least the fact that they face a regulator that seems to be singularly uninterested in actually enforcing the rules against them. It's a regulator that has some resource problems, but they aren't really facing much of a pushback at the regulatory level. And so it takes antitrust intervention to actually apply these rules. I think the difficulty with these cases is, if you look at them, all of the problem stems from inadequacies within the regulatory framework. And I think you can legitimately ask, is antitrust intervention the optimal solution here? Probably not. Fix the regulation. If that's going to prove impossible, is antitrust intervention at least an acceptable way to proceed? And third and finally, I promise I'm coming to the end of this long list of cases soon, is coordinated compliance. This is a really interesting subset of cases where we've got regulatory gaming viewed not through the lens of Article 102, so abuse of dominance by firms with market power, but actually as essentially a category of cartel. So you've got horizontal collusion, typically involving compliance with the rules. So it's not about evading the regulatory rules, it's agreement just to comply with the rules, but this is seen as an object restriction of competition. And these cases, I think, are all notable because most of them come after Carte Bancaire in 2014, where, of course, the Court of Justice said you've got to be very, very restrictive. You've got to be very, very tentative about finding new object restrictions. And nonetheless, these novel forms of behavior are characterized as restrictions by object. The paradigm example, I think, would be the car emissions cartel from a couple of years ago. So this, of course, was one of the headline enforcement actions as part of the new Green Deal. It's also a case about regulatory gaming. So the press release, when it announced the infringement decision, described the infringement as a restriction on, I think, consumer choice and a restriction on technological development. How did this restriction actually come about? Well, it's all to do with compliance with the emission standards under Regulation 715 of 2007. So this places obligations on car manufacturers to improve the emissions cleaning technology, specifically with respect to nitrogen oxide. This is an interesting area of sort of science because there's no clear answer as to what's the best thing to do at this state of technology with these particular emissions, because you can make much cleaner cars that are more effective at dealing with nitrogen oxide emissions, but they tend to be much heavier. And because they're much heavier, they're using more petrol, and so CO2 emissions go up. And so there is a kind of a bit of scientific uncertainty here. Engineers from three of the major German car manufacturers meet to have a discussion about what they're going to do to comply with these regulatory standards. And they decide, given the state of technological uncertainty, and given the fact that they know that there are more demanding standards coming down along the line, they say, for the time being, let's just all comply with the standard. Let's have bare compliance with this standard, and we'll improve our technology as these standards get more demanding. Importantly, they're all agreeing to comply with the standard. So there's no suggestion that this is one of those cases where they are trying to defeat the standard. Of course, there's a whole other strand of enforcement action against the same defendants with respect to things called defeat devices, which also relate to this particular regulation. But the Commission is really clear in the enforcement case that it's about compliance. This is not about evading the law, it's about complying with the law, but it's about complying with the law in concert. And that is the problem. That's the object restriction of competition. The agreement is not to strive for over-fulfillment of the environmental protection rules. In doing so, they're softening the competition between them that could potentially exist in this dimension. And so that's a hardcore cartel. Similarly, well, maybe not so similarly, because very different facts, but a kind of very similar outcome is the Roche and Novartis case. It was a preliminary reference case. It's actually enforcement action taken by the Italian Competition Authority. It's a really strange little cartel involving Roche, which markets a cancer drug, Novartis, which markets a macular degeneration eyesight drug. For a number of years prior to the Italian Competition Authority's intervention, the cancer drug had been prescribed off-label for use as a macular degeneration drug to treat eyesight issues. Initially, this is because there's no macular degeneration drug on the market, but even after Novartis's drug gets a license and is marketed, doctors continue to prescribe the cancer drug for the same treatment, not least because it's 10 times cheaper than the specific drug that has been produced for this purpose. Roche and Novartis are not happy with this situation, and they collude in what the Commission is ultimately happy enough to describe as a cartel, to both lobby the European Commission to have the European Commission issue some guidance against the practice, to kind of say, this is an unsafe practice and you shouldn't be doing this, doctors should not be doing this. Now, drug manufacturers have positive obligations under drug licensing law, pharmacovigilance obligations, to provide regulators, including the European Commission, with all necessary information to make informed choices. And so in one sense, what they're doing is just fulfilling this regulatory obligation. They are providing information of the risks of the off-label use. There's some suggestion in the case that they might have provided misleading information, that it might be kind of a skewed perspective. It would provide a somewhat biased perception of the risks of doing this. But the court actually says that that's not the relevant criterion. Even if the information that they provide is completely objective, unbiased, and is just about informing the Commission of the particular risks, it can still be an object restriction of competition, depending upon the purpose for which they're doing this. And the purpose for which they are doing this is to divide up the market. It's construed as a market sharing cartel because they have this restrictive anti-competitive purpose. Exercising your regulatory duties or fulfilling your regulatory duties is nonetheless an object restriction of competition. You might ask why, well, what's in it for Roche? It's clear why Novartis would want to keep the cancer drug out of the market. Why does Roche also want to do so? Of course, Novartis is only the licensee of this particular drug. The patent is held by Roche, and so they're protecting their much higher patent fees in the macular drug market. And then finally, just to kind of briefly flag the Slovak banks case, where something quite similar happens. It's a collective boycott by 3 retail banks in Slovakia. They claim that they are each boycotting a particular customer because they are an unlicensed operator in financial services. And they say, we're just doing this to uphold the integrity of the financial services law to protect consumers from this rogue operator. The court says, that's not relevant. Whether or not they are a legal operator in the market, the fact that you have colluded to exclude them, and there really seems to be the suggestion is they're afraid that they're going to become a potential competitor in future. The fact that you have colluded on this, you have this anti-competitive purpose, the regulatory framework is irrelevant. It's not going to save you. I think these cases are quite unusual, not least because of the by-object treatment here. You can also put, I think the page delay cases, they're very complicated, so I won't get into them, but I think you can put the page delay cases in the same bracket. And it's really quite novel behavior, being treated as an object restriction of competition because of the purpose for which you are colluding in terms of regulatory compliance. So where does that very long summary of cases actually get us? How much for time? Let me, I suppose, talk to you about some of the implications that I think arise from treating these cases as antitrust violations. So these interactions, a firm's interactions in a regulated market with a regulatory regime, to what extent, if we treat them as antitrust, potential antitrust abuses, what are the enforcement challenges? What are the policy questions that arise? Well, first, let me start with the substantive implications. So I've said these cases hinge on a kind of a contingent relationship between compliance or the mode of compliance with a regulatory regime and compliance with the competition rules. And given this, I think these cases raise a legitimate question as to whether the concept of competition on the merits assumes good faith efforts by a firm to comply with its binding regulatory obligations. So competition on the merits is the yardstick for compliance with competition law in Europe. Firms can compete on the merits. They're encouraged to compete on the merits, but they can't use non-normal methods of competition, whether it's singly under Article 102 or whether it's they're colluding using non-normal methods of competition under Article 101. And because of this idea that, I suppose, because our starting point that how do I'm see my face. Because these cases all seem to hinge around the idea that anything other than effective, efficient, good faith compliance can be a problem, there might be a suggestion that normal competition implies that a firm is complying with these obligations, that we assume that competition law assumes that other regulatory regimes are also being complied with. And you might say, well, what's the problem with this? You know, market actors should respect the rules of the game. Regulation exists to deal with market failures, to make markets less dysfunctional. Why shouldn't competition law assume some degree of good faith interaction on the part of regulated entities? The difficulty, I think, the problem with assuming perfect compliance, or at least efforts at perfect compliance by our firm, is that in many entities, the underlying regulatory regime is very far from perfect. And if you look at the sorts of circumstances in which regulatory gaming arises, I think you can identify three broad categories of market circumstances or regulatory circumstances in which we see these cases. The first is where you've got under-specification. So you've got a regulatory regime that simply fails to deal with all eventualities, either because these haven't been foreseen at the time the regulation was drafted, or because there was a deliberate effort to leave some space within the regulation, some flexibility for the regulation to evolve as markets to evolve, space for more responsive regulation. And these sort of underspecified aspects of the regulatory regime may create opportunities for gaming. The second circumstance in which we see these cases arising is where we've got very weak enforcement structure. So even if the regulation specifies clear obligations, the enforcement framework might be weak or the regulator might be captured. And the third is where we have value clashes. So the regulation pursues a legitimate value, but it's nonetheless at odds with the goal of competition law of securing undistorted competition, you know, linguistic plurality in the beer case, protecting public health in many of the pharma cases. That being the case, I think suggesting that in each of these circumstances, it is up to the firm to ensure good faith compliance is something which I think there could be some reasonable pushback against. If the regulation itself is underspecified, well, why shouldn't the defendant get the benefit of the doubt here if the regulation is unclear? That's the general principle in most of EU law. You give the benefit of the doubt to a defendant. And I think even going beyond that, why shouldn't firms be permitted to exploit gaps in a regulatory regime? There's a general legal maxim that everything that is not forbidden is allowed. If regulation doesn't forbid a practice, well, why should the firm have to sort of second guess the notion that a competition authority would have problems with it? If there's weak enforcement, I think it would be pretty reasonable for a regulated firm to turn around and say, if your problem is with regulatory design or how the regulator is actually enforcing this regime, why are you punishing me for these failings which are at a state level, at a legislative level? Go after the source of the problem. Don't try and put a sticking plaster on it by pursuing me. And if there's a value clash, I think this really clearly illustrates the barriers of this, so the limits of this two barriers idea. Is it actually fair to expect a defendant to prioritize competition law considerations when it decides how to comply with very different regulatory duties in other areas? Is it possible to kind of keep these two parallel obligations going when they might be diverging very, very significantly? And so I think it might be safer to say that the regulatory gaming cases suggest that competition on the merits assumes an absence of bad faith on the part of firms when complying with its regulatory obligations, not a duty to make best efforts to comply in good faith, but you simply cannot demonstrate bad faith in your interactions with the regulation, whether you're trying to take advantage of strategic opportunities, whether you're simply failing to comply because you think, fine, find me under the regulation, laughing, knowing how little impact that's going to actually have on your balance sheet. Which takes us to, I think, the defining feature of these cases. Super interesting when you read the decisions. These cases hinge on evidence of anti-competitive intention. So regulatory gaming is about the strategic misuse of a regulatory framework. And by strategic misuse, I mean deliberate efforts by the firm to manipulate, corrupt, avoid the impact of the regulatory framework. And so let me just give you a couple of quick examples of some of the evidence that you see. The Telekom Polska case perhaps has my favorite examples. The Commission obviously gets a bunch of documents from Telekom Polska, and they discover that early on in the liberalization process, as Telekom Polska was trying to draft the access rules, the CEO actually ran a project that was explicitly aimed at creating access conditions that would cause maximal impediment to the new entrants. You can kind of see the external legal counsel sitting with their hands on their heads going, oh God, the Commission has this. The AstraZeneca case, again, the Commission had documentary evidence of the evolution of the kind of misleading or the fraudulent strategy. The fraudulent strategy is based on providing patent authorities with a particular date on which the product was first marketed in Europe. There's the actual date, and that's the thing that's written down on all the documents initially. And then you see that it progressively gets scratched out, and then a new date gets written in, and that gets scratched out until eventually the people leading the kind of the patent strategy and Astra realized there's a particular date we need in order to have protection in all the different member states, and that's the one that's written down and underlined, but they've kept the original versions, the kind of true versions on all the documents, and the Commission talks about this. And Aspen Pharma really hinges on evidence of anti-competitive intent. This language comes from Aspen's own documents where they say they want a big push to increase pricing. So really going to push to increase the profit margins on these particular product lines. And so these cases hinge on firm behavior that's not merely inefficient, it's also in some ways reprehensible, a kind of more morally weighty concept. The General Court in the AstraZeneca case used the term wrongful behavior. This is, they wrongfully sought to achieve these outcomes. I think there is an argument that these cases stand in quite marked contrast to the more economic approach, and certainly there's very little emphasis on demonstrating actual impacts on consumer welfare. There's kind of a presumption that this behavior is bad, it is harmful, that it seeks to achieve a reprehensible purpose and thus should be prohibited on this basis. The thing is, competition law typically tends to steer clear of what the criminal law would call mens rea type concept. So mens rea is the idea that in addition to the bad act, you also need the guilty mind. And competition law has always been very wary of it. The EU competition rules hinge on much more objective concepts. There are, I think, at least two reasons why you might be wary of adopting intention as a standard in competition law. How do you actually show the guilty mind, the bad intention of a very large corporation? In the last panel, there was a super interesting paper on the sociology of cartels describing the very different ways and circumstances in which cartels might arise. How can you translate that into a coherent story of bad intention by the undertaking as such? And there's also the kind of perennial problem that you have in competition policy of how do you distinguish unacceptable intention to exclude or exploit for these purposes from the permissible desire to increase market share and boost profits, which the court says, even dominant firms can increase their market share. They can earn healthy profits provided they're doing so through competition on the merits. The case law on this is a little bit tricky. So the agreement cases that I've mentioned, the kind of coordinated compliance cases, all turn on purpose. So they are object cases, which is, I think, in itself quite significant, but the court talks a lot about the purpose for which you are colluding. So is the purpose to further the regulatory objectives, in which it's probably actually perfectly fine? Or is it actually to soften competition, to exclude competitors, to exploit your customers in some ways? Article 102 case is the leading case here on regulatory gaming is the AstraZeneca case, which is the only one which has really properly gone through the various appeals processes in Europe. The more recent cases that I've talked to you about all got settled, whether it was under the cartel settlement procedure, Article 9, or the kind of hybrid settlement procedure that the Commission now uses under Article 7. So unfortunately, we're not going to get much case law on those. The General Court in AstraZeneca followed the orthodoxy that abuse is an objective concept. I said, as a result, there's no need to show the deliberate nature of the conduct or bad faith on the part of the undertaking. He said, nonetheless, you can take this into account. So intention is relevant, it's just not determinative. The issue is not before the higher court of justice on appeal, but I think quite notably, the higher court of justice does use language that to me seems very like intent. So they repeatedly refer to the fact that AstraZeneca adopted these practices deliberately and that they were designed to achieve unlawful results. So they don't say you need evidence of intention, but clearly it seems to be a key component of the theory of harm on the facts of that particular case. And in Aspen Pharma, it's an excessive pricing case, and the Commission goes through it, applies its sort of long established United Brands test to demonstrate that the particular prices were excessive on the facts. But alongside doing so, they also say the context, and in particular evidence of anti-competitive intent, is highly relevant here. I don't think this is a case the Commission would have taken if they didn't have evidence that Aspen very clearly set out to game the system, that they intended to extract these very high prices that they wouldn't have been able to if they hadn't used this particular strategy. And in these cases, I think intent plays three distinct roles. So it bolsters the theory of harm. It makes it more plausible that this behavior is anti-competitive, often in the absence of any evidence of anti-competitive effects. So we're talking about object restrictions. We're talking about theories of harm that are often somewhat novel or contentious, like excessive pricing, like restrictions on parallel trade, what we used to call constructive refusal to deal, although I don't know what we call it now. But they're theories of harm that outside this particular context, often commentators raise an eyebrow about. Here, having evidence of the clear anti-competitive intent perhaps makes the cases more plausible. I think it also provides a justification for pursuing firms for what are often, at least partly, state failures in regulatory design or implementation. The argument being that, well, yes, the defendant might claim, I had a legitimate expectation that I could do this within the scope of the regulatory framework, or that if I was fined by the regulator that was enough. The problem is, if you can show that they acted deliberately to corrupt or to evade the regulatory framework, well, that's evidence of bad intention, bad faith on the defendant's part. The phrase that's often used in equity law is unclean hands. So the defendant has unclean hands and thus cannot claim that it shouldn't be treated in this way. It doesn't have a legitimate expectation in the regulatory framework, having tried deliberately to corrupt it. And I think thirdly, I'll come back to this point in a moment, I think it can also be relevant for the case law on double jeopardy. It provides evidence of a general interest in actually pursuing these cases, even after a regulation might have intervened. So those are the substantive implications. Institutional implications, by which I mean, are these the sorts of cases that competition authorities should be taking, both in terms of their formal jurisdiction? Is this behavior that really ought to fall within the purview of the regulatory jurisdiction of a competition authority? And are these cases that they have sufficient expertise to take, given that regulatory issues are often highly complicated, highly fact-specific? Can competition authorities, I suppose, competently deliver a determination that, at least in part, requires it to adjudicate on these very specific, complicated, detailed regulatory issues? I think there are three different scenarios to consider here. The first is where the regulator has found breach. So the regulator has intervened in the market, it's found a violation of the regulatory issue on the facts. In these circumstances, the case law tells us that the competition authority generally can and should rely on this as determinative. Telekom Polska involved the Commission relying upon the national regulator's determination. Roche and Novartis would have involved the National Competition Authority doing so. The difficulty is If the competition authority subsequently wants to intervene in these cases against behavior that's already been the subject of a regulatory determination, we've got this big old fair trial principle of double jeopardy. So under European human rights law, now reflected in the Charter of Fundamental Rights, I think it's Article 50, there is a prohibition on ne bis in idem, or what's called in the US, double jeopardy. Basically, you cannot repeatedly try undertakings or natural or legal persons for the same criminal or quasi-criminal type offences, even if they've been acquitted the first time or convicted the first time. You can't bring the second proceeding. The law on this in Europe, and I don't want to get too legalistic on this, but the law on this in Europe did shift quite radically last year with a case called B-Post. That previously competition law had a competition-specific standard for intervention, which was very, very narrow and very technical. In B-Post, the Court of Justice sort of brought competition law cases into the general fold of fair trial protections and ne bis in idem rules in Europe, where they basically said, if you've got parallel proceedings, a second set of proceedings against the same defendant and the same facts, well, that is a presumption that there's a double jeopardy problem, and it's going to be prohibited unless you can show a proportionate general interest in bringing the second prosecution. And this is where I think intention is going to be relevant, because if you can show that our defendant has deliberately set out to corrupt or take advantage or use in an exploitative or exclusionary way the regulatory framework, well, then I think that makes it more plausible. It makes it more reasonable to bring a second set of proceedings against it on an antitrust basis, because probably the regulatory enforcement isn't enough. It doesn't really reflect that strategic gaming behavior. There is an aspect of B-Post which I think is very underdeveloped, but in this case, the court says, if you're going to avoid a problem with double jeopardy, when you've got parallel proceedings, there needs to be coordination. So they call for quite significant levels of coordination between the regulator and the competition authority in taking the enforcement action. No indication really of what this means in practice, but you've got to show that the proceedings are conducted in a manner that is sufficiently coordinated within approximate time frame, and that any penalty that's imposed in the first proceedings is taken into account when setting the penalty in the second proceedings. The second scenario would be where the regulator has second scenario is where we've got a regulatory enforcement void. So here you've got an issue in a regulated market, you've got a regulator that plausibly could intervene, and they simply haven't. Here we've got the competition authority essentially stepping into the shoes of the regulator. The regulator might not have intervened because this is behavior that sort of sits on the limits of legality. So the regulator thinks, I'm not actually sure there is a regulatory violation here. It could be because the behavior has been hidden from the regulator. They don't really know it's going on in the market. Or it could be because the regulator simply is completely overwhelmed and under-resourced and can't get around to taking this case in a prompt manner. The difficulty with these cases, of course, we're not going to have a ne bis in idem problem. The potential objection to these cases would be if our defendant needs to actually interpret and apply the regulatory rules, which they're almost necessarily going to do if the theory of harm hinges on compliance or non-compliance with the regulatory rules. This issue is actually before the Court of Justice at the moment in the preliminary reference case that's been sent in the Facebook case. So Facebook Germany has made it to the European level. It's a case that the German court has asked the Court of Justice multiple questions. The court hasn't yet responded, but its Advocate General has in an opinion delivered last September. The Advocate General in this case was actually pretty relaxed about this prospect. He said, actually, I think he used the term incidental interpretations. Incidental interpretations are probably not such a big deal. They're not going to be binding as sort of formal determinations of the scope of the regulatory rules. They're just there to inform the competition authority's own application of competition law, and the competition authority has an obligation when acting within the scope of EU law to, he's got a duty of sound administration. So they're going to have to, be pretty competent. They're going to have to come to a determination of what the rules are going to have to decide what the rules mean, interpret the rules in a way that is coherent and consistent and takes account of relevant evidence. If they've got questions in this determination, they could perhaps send a question to to the court in Luxembourg, if they count as a court that can refer, which is always a bit tricky with competition authorities. And there's also the possibility, because competition cases take so long to complete in some jurisdictions, there's always the possibility that by the time you finish the case, actually the regulatory issue might have been resolved. Whether that's a good thing or a bad thing is something different. There's a really unusual case from earlier this year, I think it's January, called DB Station, which suggests that in one very narrow situation, this is determining access prices for rail, the regulator has to have priority. And so the court there said, enforcers of Article 102, it was a court in this particular instance, have to allow the regulator a first shot at determining the particular issue. They get priority. It is unique to the specific regulatory framework under Directive 14 of 2001. And I think it comes from earlier case law, which sort of led the court to this quite unusual determination. But there is perhaps something to be said for if it's a really, really specific task, which requires very specific technical expertise, at least giving the regulator a shot, requiring perhaps a complaint first to be made to the regulator before a competition authority intervenes. But yeah, I think that's going to be a pretty narrow point. If the regulator then acts, perhaps there's going to be a double jeopardy problem, and you'd have to show if the competition authority first acts and then the regulator seeks to act, you would have a double jeopardy issue. You'd have to show again a general interest in the duplication of proceedings. And finally, the most contentious situation where the regulator finds no breach. Now, this might be because the regulation isn't infringed, but the behavior has an anti-competitive dimension nonetheless. And remember right from the start of the presentation that non-compliance with regulation doesn't determine the question of compliance with competition law. So it's possible that charges or access conditions are perfectly fine with a sector-specific regime, but they might nonetheless amount to, for instance, an abuse of dominance. Things are more tricky, though, I think, if the source of the problem is a captured regulator. And there's this big question to which I'm not going to give you, I think, a definitive answer. Everybody will probably have different views, is to what extent should a competition authority respect what we might say is a bad interpretation of the law? Certainly a bad interpretation of the law if you're looking at the issue with your competition authority, undistorted competition hat on. Should there be deference to that interpretation of the rules? The law on this is that neither domestic regulation nor secondary legislation coming from EU law can override the treaty provisions. So Article 101 or 102 take priority. So it's always possible to find a violation, even if the behavior has been declared completely compatible with the regulatory regime. I think there might be legitimate questions that might be raised by a defendant about things like fairness, legal certainty, legitimate expectations in those circumstances where the behavior has been, I suppose, quite intimately, quite closely policed or supervised by the regulator, and then subsequently a competition authority says, yes, but we don't like it for these reasons. I think the Deutsche Telekom margin squeeze case is an example of this. And of course, sort of leading on from B post, what does meaningful cooperation look like when the regulation and competition authority are inherently at odds? In the Facebook opinion, Advocate General Rantos, when talking about the relationship that the Bundeskartellamt ought to have had with the lead regulator, the Irish Competition Authority in that instance, he said, merely informal cooperation contact would be enough, which I kind of take to mean perhaps just, sending an email. Final slide, because I know everybody wants to go for dinner. I don't actually have any content for this slide, but I do think these cases are going to raise increasingly interesting, complicated questions in terms of compliance. So there's been so much emphasis, particularly coming from the business community in the past decade or so, in terms of developing effective compliance systems, and also trying to make the case that that businesses should get credit for having effective compliance systems in place. These cases suggest that compliance obligations extend far beyond, your in-house legal counsel and your sales division, who might be setting prices or potentially dividing markets, that they go to things like, your regulatory compliance divisions, your marketing authorization divisions. Even in the car emissions case, you have to tell your engineers that when you are talking with other engineers about how to develop better environmentally friendly technology, you need to make sure that you are not coordinating your compliance with your regulatory standards. And so it just makes an already complicated business, I think, much more complicated. But I will leave it at that. That's my final words. Thank you.